USCCA CEO releases a video that appears to be in full-blown damage control mode. We got some thoughts on it. Stay tuned. This is attorney Andy Marcantel and attorney Marc J. Victor. We are the partners of the Attorneys for Freedom Law Firm here today to talk about a new video that was just released by the CEO of USCCA. How's it going, Marc?
Hey, Andy, how's it going, man? I'm out here in Hawaii, as you know, dealing with a major case in our Hawaii office. But yeah, excited to offer a few thoughts.
Yeah, it's tough work, Marc, but somebody's got to do it. I hope it's not too painful for you over there in Hawaii.
Yeah, you know, it's rough, man. It's always high 70s, low 80s here, and I feel like I have to go to the beach, you know, most days just to make sure everything's okay down there.
Well, hopefully you're balancing work and beach days, and you're taking it easy over there. First of all, you and I had a conversation about whether to even make this video today. I was initially against making this video, and the reason is I'm not interested in going tit for tat in a petty little back and forth kind of a thing with people from other programs. In fact, I've seen comments in some of the videos on both whenever companies get into it back and forth. I think maybe the most reasonable people in the comment section, I know it seems like an oxymoron, but the reasonable people in the comment section will get down there and say, hey, let your product like stand on its own merits, like there's no reason to get into a pissy, petty bullshit back and forth tit for tat. And I think that those people are right, and that's why I initially wasn't too excited about making this video. But at the end of the day, I went and looked at those same comments, and just overwhelmingly, the ones that I thought were the most telling were the people who said, is this stuff true? Like, we want more information. More information, please. I'm making a very, very important decision with my family's safety, and I want as much information as you guys can give. And so I begrudgingly kind of agreed, okay, you know, let's make this video just for the purpose of putting more information out. I don't think this undermines at all the argument that our program can stand on its own. Frankly, every single time one of these other companies even references our program, it drives more people over to our program to research. And as soon as they do what we're admonishing people to do, read the damn contracts, we usually end up stealing a number of former subscribers, now clients of our law firm. So they're really doing us favors by doing this. But I just want to be clear that I don't want to get into a pissy, bad faith kind of tit for tat for the purpose of getting into arguments on the internet. But that being said, this is one of the most important decisions that people are making. You can tell, like, in their mind, this is so important, and I agree with them. If you're ever, heaven forbid, in this kind of a situation, this decision that you made is definitely one of the most, if not the most important decision you've had to make with your money. Where are you going to place your trust? So that's why I think it's important to make a video like this.
Yeah, to be clear, we'd much rather be commenting on videos that have shootings in them so we can pick them apart and do what we lawyers like to do, or commenting on Supreme Court cases regarding Second Amendment issues, things like that. That's lawyer stuff that we prefer to do. But, you know, sometimes it requires a response. And I think this video that was put out, he never said AOR's lying.
That's right. He never mentioned us specifically or anything like that.
But it sure seemed that way to me. So I'm glad that we decided to clarify the record and get a few things straight here.
Absolutely. This video couldn't wait. We really wanted to make this video. One of the reasons is because it's kind of an unprecedented type of a video that kind of feels like a bit of damage control is going on here with the USCCA, and also just because additionally a lot of our subscribers have been sending us lots of questions. Hey, can you guys address this video? What are your thoughts on it? Did AOR fall afoul of anything here in terms of the claims that it made that are being spoken about in the video? So we didn't want to wait until you got back in a couple of weeks. We figured we would make a little Zoom video.
Yeah, man, I think it's important to know right at the start, even though the video is entitled "They Are Lying to You."
Lying's in all caps, by the way, Marc.
Yeah. Doesn't say who the they is. Attorneys on retainer is never named here, and I think that's probably intentional, because AOR didn't say anything wrong. We haven't said anything wrong. We stand by everything we said. You know, the video, Tim Schmidt, who is the chairman and co-founder of USCCA, opens up and says he's addressing what he calls unjust criticisms, false allegations, fraud, which kind of surprised me, outright lying, and deceptive half-truths.
Any leader of a big movement must be prepared for unjust criticism, false accusations, and fraud.
I watched that video actually a few times, and I didn't hear anything about that was anything close to that kind of a box.
Yeah, well, I mean, we can only speak for our own content that we've released, right? For all I know, some of these other insurance-backed self-defense programs might be defaming them or committing fraud or something like that. I don't know, but I guess this video, I really wanted to address anybody's question. If AOR fell afoul of any of these allegations that he's making on his video, and the answer, well, spoiler alert, the answer is definitely not, but I definitely want to get into the nitty-gritty of the things that he talks about, and not only the contents of the video, but some other concerns that I had from how USCCA is officially answering certain questions in their comments section. So, Mark, where do you want to start with this thing?
Well, I thought it was interesting that Mr. Schmidt basically said that many companies are trying to compare themselves to USCCA. Look, nothing against USCCA. They offer some training and education. They put out a nice magazine. And so we have nothing at all bad to say about anything that I think the good people at USCCA are doing over there. But also, we're not trying to compare attorneys on retainer to the USCCA. In fact, we're doing our best to distinguish the attorneys on retainer program from not just USCCA, but all of the other insurance-backed programs, because we're a law firm and they are backed by insurance. And that's a very important, significant difference.
Mark, you must have got a glimpse of my notes through the camera before we turned it on here, because I had the exact same note. It's like he starts by saying, we got all these other companies that want to emulate essentially USCCA and make a company like ours. And the very first thing I was thinking was, no, we're trying to create a paradigm shift away from insurance-backed self-defense programs. So yeah, I had the same thought.
Yeah. I also got to say, too, I really liked his comments about the free market. Like, we are big fans of the free market.
Now, look, I love competition. I love the free market.
And people should decide what they want. There are some things that we don't offer, right? Like, we do an annual seminar where we're going to bring the lawyers out and talk about legal issues. But really, other than that, we don't do a lot of training, and we don't put out a regular magazine in terms of these kinds of things. So I love the free market. They do training, education. The magazine, fantastic. If people want to join USCCA for that stuff, more power to them. Some people have asked Andy as well whether you could join attorneys on retainer and some other company at the same time. We don't have any issue with that at all. Never a problem. Even if one of our AOR clients had some kind of a self-defense incident and they had another program and that program brought forth another criminal defense lawyer, we're happy to work with them. I've worked with many criminal defense lawyers over the years. In fact, on death penalty cases, you always got to have two lawyers. And so on many occasions, when I've tried death penalty cases, I've worked with other lawyers, never had a problem. We are happy to work with other, what I like to call real hardcore criminal defense lawyers. So no problem if you want to join AOR in any of these other programs. You have no issue with that.
Yeah, we get asked that all the time, and some people even have a few of them. And our position on that is do whatever makes you feel the most safe. To whatever extent coverage overlaps, that's great. We will cover it. If you want another company to cover it, they can cover part of it. We can cover part of it. Our argument is simply, with our program, you don't need to do that because we've got everything you need if what you're looking for is to actually be covered in court for a criminal prosecution.
Yeah, if that's what you're concerned about, making sure you've got a team of qualified, experienced, hardcore pro-Second Amendment, pro-freedom lawyers at your back in the event you get charged with something, even if you blew it, right? If you got involved in a questionable shoot, maybe it wasn't a good shoot, you actually did commit a criminal act. As long as you say, hey, Mark, I tried in good faith to act in self-defense, we don't have a problem representing people who actually commit criminal acts. That's what we do all the time. We probably should start there. Mr. Schmidt started with, I think, lie number one. The USCCA will drop you if you're charged with a crime. Now, we don't say that because that's not the problem, right? They can represent you. The insurance company is not prohibited from paying money if you are simply charged with a crime. But I thought it was interesting. We should maybe talk about a few things in the USCCA contract. And guess what, Andy? I just happen to have it here with me.
That thing just keeps showing up at random places. There's just
Boom.
a copy on your desk in Hawaii. What the hell?
I'd like to have the writing in front of me. So just to go real fast through a couple of things. If you get the USCCA contract, which you can get online, they exclude criminal acts, right? If you look at page 2 of the contract, and maybe we'll put it up on the screen, where it says exclusions. It's on Part 2, Section B, Criminal Acts. Here's what it says. This policy does not apply to and provides no coverage for, if you look at B, criminal acts. Any criminal act by any insured, including any injury or damage caused by or during any criminal act of any insured. So you might say, how can they possibly represent you or provide funds for an attorney if they're charged, but yet still exclude criminal acts? Well, I mean, I think Mr. Schmidt kind of told you how, right? It went by kind of quick in his video, but he made the point in his video. The insurance company could decide not to cover the claim if, he said, clear evidence that it's not self-defense.
The insurance company could make the decision to not cover a claim if there is clear evidence that the member did not act in self-defense.
All right, well, see, this is the problem, right? They have to make a judgment right at the beginning. Is this a self-defense matter? Is it a legitimate act of self-defense? Or is it maybe not a legitimate act of self-defense? And he went on, he said, the insurance company is required by law not to cover it if it isn't self-defense.
The insurance company is required by law to not cover someone if it's 100% crystal clear that they did not act in self-defense in any way.
That's what Mr. Schmidt said in the video. That's the problem, right? That's the rub. So where these programs exist is in this area where they say, well, yes, he's charged with a criminal act, but we've decided that it's a legitimate act of self-defense, of course, unless you take a plea, right? Because if you take a plea, then all coverage ends.
Let's not get there quite yet, because there's something that I really, really want to focus on about what you just said, which is that preliminary decision while the insured is still presumed innocent under the law. So my first question is, who's the decision maker? The answer to that question is simple, and Mr. Schmidt admits as much in the video. It's the insurance company. Let me reiterate that. It is a non-lawyer looking at the facts of the case and making really a decision that a non-lawyer is not qualified to make, frankly, which is this a, quote, crystal clear case of self-defense, or is it not a crystal clear case of self-defense? And to have an insurance company with a motivation to disclaim make a preliminary determination while the insured is presumed innocent is the very first problem. Before we even get to ways they can disclaim you, before we get to the guilty plea, if that ends up happening, just that preliminary decision, isn't that enough for people to say, that doesn't make too much sense?
Yeah, and to be fair, the way Mr. Schmidt put it is they can deny the claim if there is clear evidence it's not self-defense.
He says in the video, there is no coverage if, quote, it is 100% crystal clear that they did not act in self-defense in any way, end quote.
Right, and even if there's a lawyer who's working for the insurance company who's in on that decision, this is not a lawyer who's representing the client. This is a lawyer who's representing the insurance company. And again, we haven't even talked about the exclusions. I noticed Mr. Schmidt forgot to mention any of the exclusions as he went through this, but they've got to make the decision whether it's self-defense, it's a legitimate act of self-defense, and then even if it is, whether it doesn't get covered because of any of the many, many exclusions that apply as well.
Yeah, I had that written down on my notes as well. which is there's not a peep about any of those exclusions. And this was on my mind today, Mark, because just before this video, I just recorded a video talking about that new gun safety bill coming up in California and what the implications of that will be for gun owners in California and how that'll affect the AOR coverage. The answer to that, by the way, is it won't. We'll still cover you even if you're in a prohibited place or you're a prohibited possessor or anything like that. Doesn't factor into our analysis. But if you're one of these insurance companies, big problem right from the get-go. If you acted in absolutely legitimate self-defense, but you were in a sensitive place or you were a prohibited possessor, which bills like to be, expand the definition of significantly, big problem right off the get-go in this preliminary determination of coverage. Not the same problem for us.
Right. And then also, I think it's important to note, right in the USCCA contract, page 2, section F, it basically says coverage ends if you're convicted of anything. It says, I could read the section here, and I'm looking from section F1. Our right and duty to defend the insured against a law enforcement inquiry or any claim seeking compensatory damages ends, and then section B, in the event of the insured's conviction of any criminal charge caused by, arising out of, or related in any way to the occurrence. So look, even if they decide that it's a clear act of legitimate self-defense, if you take a plea, like 95% plus percentage of the people in the criminal justice system do, the USCCA contract couldn't be more clear. Your coverage ends.
I got some things to say about this.
Yeah, and this is probably a good time to get into that response about pleas, right?
That's exactly what I want to talk about, because as of the day of this recording, just looking at what the top liked comments are on that video from people posting, well, number one is actually something different entirely. I wrote it down. It was pretty interesting, which is the top liked comment at the day of this recording. The user says, "The question I want answered is, quote, why was Alan Coley represented by a public defender if he had coverage?" End quote. That is currently the highest liked thing. We're going to get into that in a second. But the second highest liked comment was very, very troubling, frankly, with how USCCA responded. So somebody put, "I was under the impression that the controversy was not, quote, being charged with a crime, end quote, but, quote, being convicted of a crime. I got the impression that if your best legal option is to accept a plea bargain, and you do, you lose all coverage and will have to pay them back." Very legitimate question. Very legitimate question.
What a great question.
Here's the response from USCCA that I have a lot to say about. It says, "The point of a plea deal is to resolve the case without the cost, time, and resources associated with taking a case to trial. A plea deal is for the benefit of the courts and the prosecution. It is not for the benefit of the accused. A plea bargain is an admission of guilt, which results in a conviction on the individual's record. That conviction will likely come with the loss of certain rights. Accepting a plea bargain is, in the mind of the USCCA, a paltry and insufficient outcome for an honest citizen who is protecting themselves or their loved ones according to the rights granted to them by the Constitution. The USCCA wants to ensure that members receive true justice and that their lives are made whole again, and a plea bargain is simply not the answer. The USCCA's insurer has defended thousands of members, paid millions in coverage, and has never recovered any of the legal fees paid on behalf of the members." So when I read this, Mark, my very first thought is, a lawyer did not write this. This was not written by a criminal defense attorney who knows anything about how the criminal justice system in the United States of America works.
Yeah, and of course, to be fair, Mr. Schmidt is not a lawyer, although if he would like to come on our podcast here, as we've said many times, we'd be happy to have him on and have a very rational, civilized discussion with him or anybody else.
Well, Mr. Schmidt is the CEO. Is he the one sitting here answering comments? Probably not. It's possible he got on personally and did it, but who is answering questions like this? This is so irresponsible. It's false, first of all.
Yeah, no lawyer, no criminal defense lawyer is going to come on our program and say, you know what, I wrote that statement and I will defend it.
Hell
and if
no.
I'm wrong about that, contact us and let us know you want to come on this show. So what's wrong with this thing? Where do you begin?
Where do we begin? How about the very first thing is oftentimes, very, very oftentimes, a plea deal is in the best interest of the defendant, okay? Especially, for example, if it was a bad shoot. Let's start with that before we even get to whether it's a good shoot, which I think is what this comment, in all fairness, is aimed at. What if it's a bad shoot? And we've talked about this at length. What if you thought you were making a right decision? What if you were impaired by drugs or alcohol, which is not a defense in many states and many jurisdictions? What if at the time you thought somebody was coming at you, but they were running away? What if you shot somebody turned right before you shot him and you shot him in the back? What if the facts support some contention that a prosecutor wants to bring to say this wasn't a legitimate shoot and that the evidence tends to show that? Well, in that case, if we can get a favorable plea deal, it is definitely in the defendant's best interest to take a favorable plea deal. Say that, for example, you're charged with murder and we can get it down to something that's much lower that doesn't entail prison time, doesn't entail years and years of prison time, and we can get it down to like an aggravated assault or some lower level gun felony. You're going to lose your rights, just like he says, but if you're not looking at prison and the evidence shows a overwhelming contention that you might be found guilty, then the plea deal is definitely going to be in your best interest at that point. But then there's an even more common one. What if you're charged with a serious gun felony and we're able to negotiate with the prosecutor? How that works is we show them little peeks at what our argument may be at trial, and we convince them that we have a very strong case and the state's going to have a difficult time, and then they say, all right, fine, we've recognized that there's risk for the state to bring this type of a charge to trial, and the jury might acquit him, so we'll tell you what, how about we offer your guy a misdemeanor? Doesn't even lose the rights that he's talking about in this comment, and avoids prison time and avoids felony convictions and everything like that. You'd be an idiot not to take that misdemeanor given the circumstances. So to say that a plea deal is never in the best interest of the defendant, once again, this clearly wasn't written by anybody who knows anything about the criminal justice system in America.
Yeah, but you might say that in the case of where all coverage ends, if you're convicted of a crime and you take a plea deal and now it's going to be a big mess because they can't continue to represent you or something along those lines. But Andy, I've made this point so many times. In most very clearly good shoots, very unlikely that you get charged, right? We had a couple of people fairly recently at our firm who shot somebody and killed, in both cases, killed somebody, and in both cases we got involved and there were no charges brought. So yes, every once in a while, it's a clearly good shoot and there were charges brought. Think the Rittenhouse case, right? High profile in the midst of BLM craziness and riots and things like that with some crazy woke prosecutor. But for the most part, prosecutors aren't idiots. They do these cases just like we do. They have experts as well. They have a pretty good feel of what juries are about. They want to they'll definitely bring the case in the bad shoot, but also there's the questionable shoot, right? So many times we get a case and we look and say, I don't know, maybe this is reasonable. Maybe it's not reasonable. It depends on what a randomly selected group of people from the local community decide. And that's what it's about. It's about risk, right? We never tell anybody when you're going to trial, 100% guarantee you're going to win. There's always risk.
That would be irresponsible of any defense attorney to say to their client, even in the strongest case.
That's right. There's always risk. And in a serious gun case where you're looking at years, probably decades, maybe even natural life in a case, and you get a deal that reflects the weaknesses in the government's case, that a good, competent defense lawyer has said, look, we think we can beat your case. Here's why. There's this, and maybe we don't know for sure, but you could lose, and my guy might walk right out of the courtroom. That's what gets them to cough up a better plea. If they think, number one, we're not afraid to go to trial, and number two, we might win if we go to trial, that's what gets them to cough up a plea. And so to make a statement like this is flat irresponsible.
Yeah, absolutely. To be clear, sometimes it is definitely in the best interest of the defendant to go to trial. But how good your case looks at trial is directly proportionate to how good we expect that plea offer to be, right? Because the prosecutor wants to minimize their risk. The worst thing that can happen to a prosecutor is they spend the time and resources to bring the case to trial, and then we get an acquittal on your behalf. That usually reflects pretty poorly on that prosecutor. So if we convince them that you have a really strong case at trial, they're going to be highly incentivized to offer you something that you can live with. And sometimes that thing that they offer you isn't good enough to get the case resolved, but very, very, very oftentimes it is. And so to say something like this, I mean, at least we are clear now what the position of USCCA is on plea agreements. It's always a paltry, insufficient route to go. And frankly, this may serve as additional incentive and factors pressing their insured towards avoiding plea deals and throwing the dice with years of their life at trial. And I thought it was pretty telling and pretty irresponsible, frankly.
It is irresponsible. And also, to be clear, it's always the client's decision about whether to take a plea or go to trial. And the way you get the best plea is to convince that prosecutor you're not afraid to go to trial. And that's why you got to try cases. That's what we do at our firm. We're happy to go to trial if the client wants to go to trial.
Yeah,
but
side note, selfishly, I wish every self-defense gun case went to trial because trial is my favorite thing in the world. But it's not about what we want as your attorneys. We have to objectively tell you the risks and benefits of both sides. And you got to make the decision based on what's the smart decision for you. So to simply just completely cut out the possibility by calling it insufficient, paltry, it'll never reflect justice. Sometimes justice is reflected by plea agreements. Oftentimes justice is reflected by plea agreements, and it's all about risk assessment. So why neuter one whole tool in the toolbox, which is a significant possible set of avenues for your client? That just seems ridiculous to me.
Okay, couple other things that I wanted to just point out in the USCCA contract, because it's in there, page 2, Section E, USCCA chooses the lawyer. You don't get to choose your lawyer. I think it's pretty clear in here, Section E. We have the right to assign counsel of our choosing to defend the insured against any claim arising out of an occurrence or incident resulting in covered legal liability to which this insurance applies. It does say we will not unreasonably withhold approval of defense counsel requested by the insured, provided that such counsel, in our sole judgment, has the necessary professional experience to defend the claim. And I don't like this part either, number 1, counsel agrees to operate within our litigation and panel counsel guidelines, whatever that means.
Well, we've talked about the possible ethical problems with having your lawyer have to comply with the counsel of an insurance company, especially if compliance means giving the insurance company maybe some bad facts that they stumble on in the investigation of the case, knowing that if they turn that over and cooperate as required in that clause of the contract, the insurance company may find a new way to leave their client high and dry. That's a pretty bad ethical conflict to be in as a defense attorney.
And then number 2, the attorney agrees to our usual and customary rates and billing guidelines. I don't know what those are. They don't publish those. My rate is $650 an hour. I don't know if USCCA would be willing to pay that. But anyways, that's in there, and that's something you got to deal with. Another area of the contract that I wanted to point out, USCCA's contract, page 4, unlawful use or possession of a firearm. Use or possession of a firearm or other weapon in violation of 18 United States Code Section 922 or other applicable federal law. What's this going to include? There go your prohibited possessor, illegal weapons, anything that violates federal law. If you had controlled substances, you were using them at the time. Domestic violence restraining order, if you're under indictment for a crime, if it happens in a school zone, there's all kinds of things. Take a look at 18 USC 922. So there are tons of exclusions here. I noticed Mr. Schmidt didn't mention anything about the exclusions, and people can view our contract online. The attorneys on retainer contract has a section in it that specifically says these things are not excluded. And then we have the same laundry list that so many of the insurance-based companies put in there, except they're excluding them, we're including them.
Yeah, once again, not to harp on SB2 in California, but when you see legislators try to get stuff like this passed, where they're kind of clinging to that little thread of United States Supreme Court decision in Bruin and trying to expand the meaning of what it means to be in a sensitive place and what it means to be a prohibited possessor, how you should interpret that if you are subscribing to one of these insurance-backed companies is, here comes a law that greatly increases the chances that you are going to be excluded under one of these exclusions. It's just basically adding more and more possible ways for these places to exclude you.
Yeah, final thing on the USCCA contract, because we want to be very accurate, right, with what we're saying. Page 8, Mr. Schmidt talked about the section I, the recovery or recoupment section. Here's what it says. We shall have the right to seek recovery or recoupment from an insured, the amount of any payments made to, for, or on behalf of the insured, including payments made to third parties, if it is determined that any such payments were made for matters not covered by this policy or are otherwise prohibited by applicable law. Now, I noticed that Mr. Schmidt said in the video, when he talked about recovery and recoupment, he said it was due to fraud.
The insurance company does, in fact, have the right to recovery and recoupment in the case of fraud.
But that's not exactly what the contract says. What the contract says, if they make payments not covered by the policy, you mean like it's a criminal act? You mean like you pled, you're in the 95+% of people in the system, and you pled guilty to a crime? Now, look, I'm not saying that they're going to exercise that section. I don't have any information if they have or they haven't. But when you say we have a right to recoupment for fraud, and that's not what the contract says, I think it's fair to say, look, here's exactly what the contract says. People can make their minds up for themselves. Again, I always say, don't take our opinion for it. Pull the contract yourself, read it for yourself. You'll see.
Read the contract, and if you can get past the exclusions exception and still say, yay, I'm on board with this, which once again, he didn't make a peep about in this video. And by the way, if we're clearly lying or being deceptive with regard to the fact that there is this myriad of exclusions, please correct us. We are waiting with bated breath to hear what they have to say about this laundry list of exclusions, which I think is the most important problem with these companies. But if you can get past that, yes, read these contracts for yourself. It's all right there in writing. And we proudly post ours up online. Go and check out ours and read it for yourself before giving anybody a dime of your hard-earned money. He talks about the clause in USCCA's contract that will indemnify somebody for civil damages, and he talks about a case where they paid out $500,000 to one of their subscribers because they were, I believe, acquitted criminally but then sued civilly. This is, to be clear, this is not something Attorneys on Retainer does at the moment. We have been, as you guys know, who've been following our program, we have improved it immensely over the last few months. And as we always say, every single time that we release a video making an additional improvement, we always say, and we reserve the right to continue to improvement, though we do not offer this at the date of this recording, which is the end of December 2023. But there's something really odd that goes on here. So imagine that you're somebody who doesn't have enough money just sitting around in your bank account in order to hire a good, competent self-defense, criminal defense attorney in the case that you get charged with a crime. Well, that's why people get these programs, right? It's because not everybody has the usually 6 figures it takes to take one of these cases to trial, or even if it doesn't go to trial, immensely expensive to hire a criminal defense attorney in a serious case like this. You don't have that kind of money sitting around. So there's a really weird thing that goes on here when a company offers you to indemnify you if somebody sues you civilly as a result of this. So just to kind of put this in the real world context, whenever somebody goes to a civil attorney and they are assessing a case for whether it makes sense to sue somebody for something, one of the very first questions that civil attorney is going to ask is Is it even worth it to sue this person? Do they have the resources necessary to make it worth you to sue? Attorneys do not work for free. That civil attorney is going to say, here's my hourly rate. Here's how many hours I expect it to be to sue this person for, say, wrongful death or aggravated assault with a firearm or something like that. Usually it's going to be to the tune of many thousands of dollars. And so the question they're going to ask is, what do we know about this person's resources? Does this defendant have resources that we actually stand to collect that can wipe out my attorney's fees and then go to you? Well, if you don't have any resources such that you can't afford to hire an attorney, and so it makes more sense to go with one of these programs in the first place, by offering to indemnify you in a perverse way, USCCA is inviting a plaintiff to file a lawsuit against you where you would have otherwise had no resources to collect. So you may have now just inadvertently ended up in an unnecessary civil suit, and these things can drag on for years, Mark.
This happens at our firm all the time, right? We have a civil department. People come into our firm. They say, hey, I want to sue somebody. The first question out of the box is, do they have anything to go after? Is there insurance, or do they have money in the bank that we could go after? Usually equity in a home can be protected by a Homestead Act. You can't go after that. And so we refer to people who don't have insurance and don't have money as judgment proof. And the reason we say that is because you could get a judgment against them, but you can never collect it. So in a weird way, as you're pointing out, by saying, oh, yeah, I got a $500,000 or $1 million liability coverage now if I get sued, that's what the kind of thing that encourages plaintiff lawyers to bring cases. But to be fair about it, like you said, and to be crystal clear on it, the attorneys on retainer program will defend you if you get sued as a result of a self-defense related incident, right? We have a civil department. We'll take it all the way to trial. We'll defend you. But if it ends with a judgment, we don't pay that judgment. That's an insurance company thing. So assuming that the insurance company is going to cover the case initially, and assuming you didn't take a plea on the criminal side lose that coverage, right? Because if you're in the 95% group of people who take a plea in the criminal side, then you lost all your coverage on the civil side. There's an advantage for the insurance company if you can run through the gauntlet of exclusions and all of that, and then you still get sued and there's a judgment against you at the end of all that. Better to have the insurance than not have the insurance. So that is a legitimate ding on the attorneys on retainer program. It's probably the only one, but this is, we're not an insurance company, so we don't indemnify people against the judgment.
Yeah, we're all about the criminal context. We're all about the criminal defense. We have an excellent civil department, like you said, Mark, that can definitely defend people. And if this person doesn't have resources to go after, if one of our AOR clients doesn't have resources to go after, it may be as simple as our civil department convincing the plaintiff's lawyer that there are no resources, that our client is essentially judgment proof. And at that point, they could abandon ship on the lawsuit because it doesn't make sense for the plaintiff to spend thousands and thousands and thousands of dollars on a lawsuit that's going to get a judgment that they can hold in their hand and say, yay, I got a judgment, but then never be able to collect it.
So moving right along, Mr. Schmidt decided he would talk about the Kayla Giles. I don't know if it's Giles or Giles.
He says Giles in the video, not sure.
He says Giles in the video. I don't know. But it was kind of surprising to me that he was openly discussing the facts of that case. Now, we don't have any way to verify this. We haven't seen the video. We don't know what her internet search history is or says.
And to be fair, no ethics problem with him doing this. He's not a lawyer. I believe he's not a lawyer, and so he's allowed ethically to blab about it. But then there's the kind of moral question, and then there's the PR aspect of the fact that he's blabbing about somebody they didn't cover and said she obviously murdered her husband as part of a YouTube promotional video. Not great optics.
Yeah, it just kind of hit me the wrong way. I'm like, this was your member at USCCA, and you paid $50,000 to this lawyer, who, by the way, you and I spoke to, and this guy was no slouch. This guy had been practicing a long time, and he reviewed all the evidence. He had the video, saw the video, and he thought it was a defensible case for self-defense. He doesn't know why USCCA pulled the plug. But then Mr. Schmidt made the point that she sued USCCA and lost. Well, okay, that's true. And she should have lost. Why? Because they exclude criminal acts and she was found guilty. But think about what this means and how this plays out, right? If I'm the insurance company, I could deny 100% of the claims that came in, 100% of the criminal cases. And again, to be fair, I am not saying that USCCA is doing this, has done this, would do this. Just speaking hypothetically here. If the insurance company wanted to say, we'll have a policy, we're just going to deny 100% of them and say, you know what, we think they're criminal acts, they're going to be right in 95% plus of the cases. Because anytime somebody takes a plea, they'll say, aha, we were right. We denied it because, look, the person pled guilty. In the, let's call it generously, 5% of the cases that go to trial, maybe 50% of those end up in a guilty verdict. If not, a lesser included guilty verdict, which can be a big win for the defense to beat the big charge.
Yeah,
but
take a look at the Alan Coley case, right?
Take a look at Alan Coley. So in at least 50% of those, we can say they're going to be right in denying the claim. That leaves 2.5% of all of the cases, if they denied coverage, that they could be wrong about. And of course, their liability is limited to the amount of money they would have paid for the criminal defense lawyer in the first place. It's really in their interest financially to just deny the claim, because they're going to be right under this analysis under 97.5% of the time. They're going to say, we were right, we denied it, but look, there's a criminal act. So I think that's something people should think through on their own if they're in one of these insurance-based programs.
I still can't get over that ridiculous, absurd plea deal comment saying that it's never in the best interest of the defendant to take this. And just thinking aloud, he proudly touts in the video that they've represented thousands of people in self-defense related incidents. I wonder if all the thousands of them went to trial. I wonder what percentage of that took the paltry, insufficient miscarriage of justice that he's condemning under the plea bargaining rules. I'm highly skeptical that thousands of them all went to trial because that's the right thing to do in 100% of the cases, and that's what USCCA is interested in. So, yeah, there's some food for thought.
We know that's not the case, right? I've been practicing 30 years. We know that's not the case. Okay, so can we get to the big elephant in the room here?
Before we get to the big elephant in the room, before we get to Mr. Coley, I want to say one more thing about Kayla Giles, but really it's not even about Kayla Giles that I want to say this about. It's about a really important concept in the legal system of the United States of America. It's one of the things that makes me proud to be a criminal defense attorney, in fact. And it's the presumption of innocence. Let's talk about what that really means. Are we all serious as a society with this presumption of innocence thing, or is the presumption of innocence only afforded to some people? I could hypothetically tell you that Kayla Giles, even if she had searched that day and her internet history was recovered, and it says, plans on killing my husband at 5:52 p.m. tonight, and then she fires the bullet at 5:52, she is still presumed innocent, just like the Boston bomber is presumed innocent, just like school shooters are presumed innocent. Are we serious about this presumption of innocence thing as Americans, or are we not serious about it? And the role of defense attorneys is so important. We have a tough job. We have a really tough, important job. And that is to say there's certain concepts as Americans that we can't abandon if we want to have a good justice system. And we are not in any way, shape, or form ashamed to say that we would cover her even if there was overwhelming evidence of her guilt. As long as I can get a self-defense jury instruction, I'm going to discharge my duty proudly to make sure that she has the best darn defense that she possibly can. So I just wanted to say, guys, let's think about this real quick. I mean, this is an important concept to what makes us a great country. It's what makes our criminal procedure so great. And to simply cast it aside, I think a little bit too willingly, even if the evidence is overwhelming, the role that we serve is so important. Mark and I have a million cases we could have told you that initially the evidence looked overwhelming. And then the more we dug into the case, we found, holy cow, it surprises even me. This person is absolutely innocent. I'm glad that they got somebody who took the time to fight for them, get them in a better position, everything like that.
Yeah, man, I'm so glad you kind of went on your soapbox there, because it's really true. Sometimes at the beginning of the case, we look at it and we think, because remember, the vast majority of stuff we've been doing all these years has nothing to do with AOR, which is criminal defense lawyers. We look at the case and think, this is a really bad case, right? We're going to be screwed on this case.
Happens all the time.
Yeah. And then we start getting into it. We dig into it. We understand the story better. We start talking to other witnesses. And we say, you know what? This is a defensible case. This is a much. How many times in the middle of the case have we sent a written deviation request to the prosecutor with new information, which frankly we struggle with? Do we want to spring it at trial,
or do we want
to try to get as a trap, or do we want to try to get the better plea early? In fact, we got one right now that's exactly in this
Mark,
situation.
you and I have cases in the office right now where they definitely were planning to commit the crime, were on the way to commit the crime, and then we discovered evidence. We were able to dig up evidence that showed they changed their mind about committing the crime on the way to committing the crime and withdrew, which is legally relevant. It's legally relevant that they withdrew prior to, or that something new happened during that incident that caused all of a sudden their conduct to be legally justified. Even if you planned on killing somebody, there are still instances legally where you could be justified in self-defense. So, yeah, man, the presumption of innocence is just something that was completely bereft of any of these conversations. It keeps going back to they're just obviously guilty, so therefore, you're not siding with criminals, are you, wanting to be on that side of the argument? There's something so much more important here, and I know I'm back up on that soapbox, and I'll get off of it now, but I just want to make it really clear that that's one of the reasons why I'm so proud to do the job that we do, and we have a very different mindset. Once again, we are not looking to build a structure like USCCA. We're trying to make a paradigm shift to really highlight these important differences between working with an insurance company and working with a real law firm.
Yeah, I'm glad you said it, Andy. It gives people a flavor of what real criminal defense lawyers are like, and maybe contrasting that with sort of insurance-based programs and people that don't do this stuff. We would never have made a comment that USCCA made with regard to plea. But let's move on.
I kept saying over and over and over again, a criminal defense attorney did not write this. A criminal defense attorney did not say this. Okay, Mark, finally we can get to that big, fat, juicy elephant in the room that I know you've been champing at the bit to talk about. You want to tell us about your thoughts of Mr. Coley and how it was addressed in this video?
I think, to be fair, we should remind everybody of what we said way back at the beginning in regards to Mr. Coley's case. If that's the case, and again, we don't know for sure. We're speculating. I mean, I know what Mr. Pouliard told me, but we haven't spoken with Mr. Coley. We haven't seen any contract with USCCA or anything like that. I mean, I could imagine maybe Mr. Coley wasn't paid up on his dues or something. Who knows? There could be some things.
Yeah,
like
if we're wrong on this, we're definitely going to come back and do right by USCCA and finish the story, basically. But based on our conversation with Mr. Coley's lawyer, it appears to be the case that he was a USCCA member.
So I think we've been very clear from the beginning that we don't have all the information. And frankly, we still don't have all the information in this case. But one thing we learned from this video that we weren't 100% sure about before is Mr. Coley definitely was a USCCA member in good standing at the time of that incident. There is no question about that. And the question that's on everybody's mind, if you look at the video that Mr. Schmidt released to deal supposedly with this situation, Andy, what is the most common comment on Mr. Schmidt's video?
Quote, why was Alan Coley represented by a public defender if he had coverage, end quote. As of the day of this recording, that is definitely the highest rated comment, highest liked comment, highest commented on comment of people saying, yeah, what that guy asked.
I mean, it kind of speaks for itself, right? I think. I'm not sure how much we need to say about this. The guy was a USCCA member. He got involved in a shooting. We saw the video. Right? Admittedly, it doesn't look like a clearly good self-defense shoot, at least not initially.
Go check out our legal analysis of it, because there's a lot of really interesting things to say about it that I think can also kind of tease out some of the differences between why these other companies have to disclaim coverage and why we don't have the same problems. But go on, Mark.
One thing for sure, he had a public defender, because I spoke to that public defender. And he did some research himself, because apparently Mr. Coley told him about USCCA. He looked at it. He saw what he told me was he saw the exclusion for criminal acts and said, this doesn't cover this kind of situation. It's for civil. And he moved on. And so now think full-blown damage control mode. USCCA, for reasons they haven't stated yet, have decided, we'll pony up some money to get a lawyer to represent him on appeal do we really need to say anything about what's going on here, Andy? People can connect the dots, and they are connecting the dots.
I want to be conservative here. I mean, because it could very well be that there's some sort of an explanation or revelation that we're in for at some point down the line. But suffice it to say, it raises a heck of a lot of questions. This video, in my opinion, raised more questions than it answered. And so I think that we should, at this point, withhold judgment on that. But it certainly is getting everybody talking.
Yeah, and he made a big point, Mr. Schmidt did, to say that Mr. Coley was not dropped as a USCCA member. Okay, I mean, it's great that he wasn't dropped as a USCCA member. That's fantastic. That's not the question. Question, why wasn't he provided at the USCCA insurance company expense exactly what he bargained for, a private, qualified criminal defense lawyer? Why did he go to trial with a public defender? Now, fortunately, he got a good public defender who did a nice job on the case, and we're trying to get him on our show, and I hope we can, because I like to talk to the guy, did an excellent job on this case, but we didn't get any answers from Mr. Schmidt on this, and that's what everybody wants to know, and that's what people are connecting the dots on. He says he can't talk about it because it's an ongoing case. If they thought that was going to satisfy people, they got to be out of their minds, right? Because you just talked about the Kayla Giles case. You're not a lawyer. You got no attorney-client privileged information about the case. Even if you did, you're not subject to the attorney-client privilege. You could be sent a subpoena by the prosecutor and deposed and asked a question. Tell us everything you've learned from any source, Mr. Coley, his lawyer, anybody else. Tell us everything you heard about this case, and you have no right to refuse to answer that question. So I don't buy the we don't talk about ongoing cases, especially after you just threw Miss Giles under the bus in her case.
Absolutely.
Yeah, I mean, it's just
you know that I have a theory on this, and I'll restate it again. And it's just a theory. I don't know if it's true, but it makes perfect sense to me. You hear all these insurance-backed companies talk about all the time. The reason why we have exclusions for criminal acts is because it is illegal to insure a criminal act. That is a fact. In the United States of America, it is illegal to insure a crime. It is illegal to insure a criminal act. So say if you're in a case like Mr. Coley's, where there's two charges on the indictment. Charge number one is where the prosecutor is arguing that he didn't legitimately act in self-defense. Maybe USCCA looks at that. Maybe they even like the case, and they say, hey, I really like that case. I think we can argue self-defense on that. We'd love to cover it, but there's a second charge in there. He fired the gun in a mall, which is one of these sensitive, safe places in that jurisdiction. And there's no arguing from the video that he didn't shoot the gun in the mall. He definitely shot that gun in that mall. And so they could have looked at it and said, well, we can't cover the second offense, and it's part of the same indictment. It's part of the same complaint. So the question I have in my working theory is, they can only take your case if there's like a singular charge for acting in self-defense, and they can't cover anything, even if it's not even the biggest charge in the indictment, if the evidence is overwhelming of your guilt in that, as they call it, right? And this is where, once again, the presumption of innocence comes in for us. We don't care. We don't follow these exclusions. We don't care if you were in the wrong place. We don't care if you were the wrong person. He could have been drunk with an illegal firearm in a sensitive place as a convicted
prohibited
felon,
possessor.
as a convicted felon with a sawed-off, and we would have said, absolutely, if you acted in valid self-defense, that's the end of our analysis.
Or even if you tried to act in self-defense, right? If you in good faith tried to act in self-defense. But Andy, I'd push it a little further and say, look, we don't know the answers to this. But even without that second charge, say they don't even bring the second charge, it's possible the insurance company looks at that and says, we think it's a valid act of self-defense, but it happened in a place where you can't have a firearm. And even though there's no charge, we're still going to deny it on that basis. Now, I'm sure
they don't need the second part. Yeah, they don't need the second charge at all.
I'm sure, knowing what they know now, I'm sure they wouldn't have denied coverage, right? But after the thing is blown up and everybody's now saying, I don't want to be with USCCA in full damage control mode. And again, we don't know for sure, but it sure looks like that, right? They say in law school, if it looks like a duck and it quacks like a duck and it walks like a duck, it's probably a duck, right? And so I think we know what's going on at USCCA. It sure looks like full-blown damage control mode. They won't answer the question why Coley had a public defender. No matter how many times it's asked on that video, this was their video to address this problem. I would have said, don't even make the video if you're not going to answer the question why Coley had a public defender. So, to be fair, another guy who I don't know and I have never spoken to, and he seems to be a USCCA member. He runs a YouTube channel called Legally Armed America.
He's not an employee of theirs. He doesn't get paid by them, and he says that in the video, to be fair.
He seems, and I take the guy at his word. He seems like a pretty straight-up guy. He says he's been a member of USCCA since 2016. Certainly looks very friendly towards USCCA. But he had some interesting things to say about this video. Maybe we could put a link to his video at the bottom of ours. He started out by saying, look, Tim's a salesman.
Again, with all due respect to Tim is a salesman.
He's certainly not a lawyer. And then he made this other point. He said, how do you know if there is clear evidence it wasn't self-defense before the trial?
First of all, where he talks about if there's clear evidence that you did not act in self-defense, well, isn't that the purpose of the court system, right? In other words, how do you know that if the trial hasn't taken place yet?
That was something he asked. That kind of gets right to the issue. And he says, I'm kind of confused about this concept. He says, wouldn't that just be an opinion that could be used to deny coverage?
So is this an opinion that somebody can make prior to a trial to not cover somebody?
Yes, I think he made some very good points over at Legally Armed America. He says he made the obvious point. Now we know Mr. Coley was and still is a USCCA member in good standing. And then he said some interesting things, I thought, at the end of his video. This is him, not me. He said, quote, insurance companies do not exist to help you. They give you coverage if they have to. End quote. Those were his words. And then he also said, quote, they want to pay out as little as possible. End quote.
All true.
Okay, maybe he stated the obvious, right, about insurance companies. But then he went on to talk about attorneys on retainer. He even had a little clip of us talking about the Coley case in there, and I appreciate that. Thank him for putting that in there. Because, of course, we stand behind what we say in any forum. But then he said, quote, the attorney's goal is to get you off. They want to win.
Their business model isn't necessarily to give you as little as possible. Their goal, they want to win. Their team of attorneys want to win those instances.
Yes, damn straight.
This guy gets it. This guy has connected the dots. And
he's connected the dots.
Mark, I've been saying this for months while we're getting this program up and running. If the average citizen who wants to be protected in the case of a self-defense shooting simply were to have all the information, simply be given the information, the differences between a law firm and an insurance-backed program, we would rule the market. Like, as soon as people make this connection, right, that we are highly incentivized. And in fact, the free market, which Mr. Schmidt talked about, we agree with his hailing the free market. The free market regulates our conduct. If we do a poor job on people's cases, because as the YouTuber you just correctly pointed out, we want to win. And there are selfish reasons that we want to win. We want our clients, obviously, to get the best result so that they will go and tell people about the representation that they received, so that more people will sign up for our program, so that we'll get more 5-star reviews, so that the reputation of our law firm will increase, so on. In other words, the same principles that have made us a reputable law firm for the last 27 years, same exact things at play with this program. It's very simple.
Yeah. I mean, look, we're not confused about the fact that we don't have to say, no, sorry, it's a criminal act and we can't do it. We represent people who commit criminal acts all the time. Who are we trying to exclude? We're trying to exclude the gangster or the thug who says, you know what, I'm going to go out and rob a bank. I'll sign up an attorneys on retainer and get them to defend me for free. Okay, that's the kind of situation we're trying to exclude. And so that guy's going to have to hire us and pay the freight to have us defend him. But if you're an average, competent, responsible firearms owner, and even if you screwed up, you acted in self-defense.
Even if you screwed up, none of these other companies can say that legally.
Yeah. You try, as long as you say, look, Mark, I thought I was acting in self-defense, in good faith, right? You're not lying to me. You're saying, in good faith, I thought I was acting in self-defense. I tried to act in self-defense. No problem. It's not a big deal for us at all. We're not going to have an insurance license revoked for covering people in criminal acts or anything like that. We're happy to do it. I'm going to bring that case in, and our criminal defense lawyers are going to jump all over and say, who gets this case? I want this case.
You know what Mr. Schmidt calls it when you make a claim to the insurance company, they cover you, and then you end up maybe taking a plea or something? He calls that fraud. He says at that point, it's a fraud, and we can recoup. That's when the recoupment kicks in and everything like that. In other words, I think how he's trying to frame this, right, is that you made a contractual claim and saying, yes, I am making the legal claim that I acted in self-defense. And then if you end up taking a plea deal, or if a jury in your jurisdiction convince you, oh, now all of a sudden you've committed a fraud on the insurance company? Really? Is that the language? It's just this is all dicey, playing around with language. I'm just so glad we don't have to do any of this stuff, Mark, as a law firm.
Andy, let's end where we started. We got nothing against USCCA. We think there are good people over there who care about this stuff. We're probably all aligned on Second Amendment issues, maybe even the broader pro-freedom issues. We think people are acting in good faith over there in a lot of ways. They're restrained because there are restraints on insurance companies. USCCA, as best we can tell, is fantastic for training, education. They put out a great magazine. They have good people over there. We don't say anything bad about any of that stuff. If people want to join USCCA for that part of it,
it seems like Mr. Schmidt is clearly trying to act in good faith for the most part in this video, but he's stuck with his product. He's stuck with what they got. There's reasons he can't address this overwhelming wave of people saying, "Tell us about what's going on." Why? Like exclusions? Like what is all this recoupment? He's stuck with what he's selling.
Yeah. And if we got something wrong, by all means, I'm very, very easy to get a hold of. People can email me directly. It's just Marc, M-A-R-C, @attorneysforfreedom.com. You can call the law firm and say, I'd like to talk to Marc or Andy. We're very easy to get a hold of. You want to come on and have a discussion with us about anything we've said? If you think we got something wrong, let's talk about it. If we did get something wrong, we'll say, oops, we made a mistake. We'll own it. We won't say it again. We'll correct it, whatever. No problem. We are a very high character operation. Our firm's been around since 1997. We have thousands of happy clients. We got lots of 5-star reviews. We're not playing any games at our firm. We got criminal defense lawyers who like to represent people in pro-freedom cases. We love self-defense cases. Every lawyer at our firm is hardcore pro-freedom. And so that's our craft. That's what we do. And that's what we're offering people with attorneys on retainer.
The big question I have is, how on earth did we manage to blab so long about an 8-minute video? There was a lot to say about it, though. So I'm glad we teased out all of these issues. Any closing thoughts, Marc?
No, I think that people should get informed. Like you said, Andy, read both contracts. Ours is right out there. People can go to attorneysonretainer.us. Go to the FAQs. There's a question in there. How can I see the fee agreements? Go down, read it. If there's something that doesn't make sense to you, or maybe you think contradicts anything we've said, reach out and we'll be happy to answer your questions. No problem. So do your homework. Figure out what it is you want. If what you want is to be pretty damn sure you're going to have qualified, experienced criminal defense lawyers standing next to you in court just when you need them, you're not going to be hung up on a criminal acts exclusion or any of these other countless exclusions. If that's what you want, probably attorneys on retainer is the best choice. If you want all the bells and whistles, like we don't do handbags, we don't give you little trinkets or any of those
things. Hey, man,
things.
We reserve the right to start carrying swag. In fact, I've noticed a lot more comments saying, you guys need to carry swag. This seems like a low transaction cost for us, Marc, to make the people happy.
I already know.
We need to talk about this in our next marketing meeting.
There's a few shirts that have come across my desk, so I think there will be some attorneys on retainer shirts coming. But you get the point. We're about criminal defense with attorneys on retainer.
That's right. Less bells and whistles and more strong legal defense for your criminal matter. Thank you guys very much for tuning in and listening to us blab and blab about this video. We thought it was really important, and we know you guys wanted to hear about it. Tons and tons of comments. And keep commenting on our videos. We love it when you guys leave us comments, ask us questions. We especially love it if you think we got something wrong in one of these videos. Leave us a comment. We'd love to engage with you guys. Like it, subscribe it, share it with a friend if you liked it. Visit attorneysonretainer.us to learn more about what our program can do for you. If you want to learn more about our law firm and about the type of criminal cases that we handle and the type of work that we do and the principles that we stand for, attorneysforfreedom.com. Until next time, my friends, this has been Attorney Andy Marcantel and Attorney Marc J. Victor. Peace.
Peace.